Good day and welcome. My name is George Quillen. Foley and Lardner is hosting today's webinar on Post-SAS. We're grateful that you've torn yourselves away from the World Cup. And so the next hour, instead of watching the beautiful game, we hope that we'll have a beautiful presentation for you to see. Before we get started, we've got a few housekeeping matters to deal with. Taylor?
Yes, thank you, George. Today's program will last approximately 1 hour, followed by a short question and answer session, time allowing. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you have difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email with it to Taylor Bannister at tbannister@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. Please note certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form to Taylor Bannister at tbannister@foley.com immediately following the program. At this time, I'd like to return the program to our speakers. Thank you.
Let's have the presenters introduce themselves. Bill?
Yeah, good morning, everybody. Bill Robinson, Foley and Lardner, LA. I'm chair of the Intellectual Property Litigation Group. We're basically technology trial lawyers. If it's patents or cryptocurrency, that's what we do. George?
I'm George Quillen, a partner in the D.C. office of Foley and Lardner. I'm in charge of the firm's patent office trials practice. I've been involved in IPR since the very beginning, and before that I've had a couple of decades of experience in patent interference practice.
Hi, this is Andrew Cheslock. I'm in the D.C. office as well. I'm also a member of the Patent Office Trials Group, have been involved in IPRs and AIA proceedings since the beginning, and before that had a practice working on inter-parties and ex-party re-exams.
Hello, I am Michelle Moran. I am located in Milwaukee. I'm a member of the IP litigation practice, but I also have worked on IPRs with George, and welcome.
Great. Well, thank you all very much. We hope today, time permitting, to cover these 6 topics and have a period of question and answer at the end. To get us started off, here's a reminder of how we got here from SAS. You may recall that the question that was presented to the court had to do with the scope of a final written decision. So if the board decides to institute trial, does the final written decision have to address all the challenged claims, or it can address only some of them? And the court's pithy response was, when you institute trial, it's got to cover all the claims that the petitioner has challenged. So although that was framed in terms of claims, subsequently, in the Federal Circuit decisions and the PTAB, the practice has been to institute not only on the claims, but on all the grounds. We're going to speak first about what's been going on at the Federal Circuit. These next few slides about the Federal Circuit are organized primarily around the theme of remand. So the first case has to do with the patent owner. Surprisingly, there are occasions when a patent owner can request a remand. In this case, Polaris, the board had instituted an IPR on only a subset of the challenge claims and on only some of the grounds. Final written decision held the claims unpatentable, so, as you can imagine, the patent owner, Polaris, appealed. After the appeal briefs had been filed, and after SAS came down, the patent owner, Polaris, moved to terminate and remand. Says the court, under the circumstances of this case, where it's the petitioner who's making the request to remand and no merits briefing has yet occurred, we find that it's the most efficient course of action to remand for the board to promptly issue a final written decision as to the challenged but not instituted claims. Importantly, says the court, doing so will ensure later on that there's no dispute or concern in the parallel district court proceedings regarding the scope of an estoppel. Well, what about waiver? This happened after all the briefing had been done. There certainly hadn't been a challenge at the board level to all this. So the court addressed waiver, saying that that's okay. That the Polaris had not waived its right to seek remand by not arguing against partial institution before the board. So it was okay to do what it did. What about petitioners? What about petitioners? Petitioners, of course, can request remand, and when can that be done? Here there are two cases at sort of opposite ends of a timeline spectrum. First is Althera, which happened before there was any briefing. So the board had instituted an IPR in most but not all the challenge claims, and its final written decision held the petitioner, Althera, had failed to prove unpatentability. Althera appealed, and before filing its opening brief, Althera moved to remand. And that's where the court had said that it's okay. And then in the opposite end of the spectrum, after the court had entered its judgment in broad ocean, the court says that's okay too. So there the board had instituted an IPR on only claims 7 to 13, but not on claims 1 to 6. The board's final written decision ruled against the petitioner, so the petitioner, broad ocean, appealed. The court affirmed in a Rule 36 judgment. And after that, broad ocean sought rehearing, urging remand regarding the non-instituted claims 1 to 6. The court agreed that remand was the right thing to do, but interestingly, the court did not vacate the final written decision. Rather, the court vacated its own Rule 36 judgment, but then again affirmed the board's determination that claims 7 to 13 had not been shown to be unpatentable. Hence, the court remanded to the board for a final written decision addressing claims 1 to 6. Now, what about if both parties request remand? Well, that's happened too. Here, in this Nestle case, the board had instituted a trial on all the challenge claims, but on only 1 of 5 asserted grounds. Each party separately sought remand in light of SAS. And the court wrote, both parties agree that remand is appropriate. And then after discussing what the parties disagreed with, the court says, quote, we agree with the parties that remand is necessary and appropriate in light of SAS and Polaris, close quote. Necessary and appropriate. Think of hold that thought for a while. So there are also other circumstances where there's been a remand. In this Medtronic case, the court had vacated a board decision that certain references were not prior art. So the case is going back to the board for an evaluation of that. Well, as long as you're going back to the board, says the court, the final written decision had not addressed every ground that had been raised in the petition. So referring to the board's recent guidance, this guidance in April of 2018, the court said, we understand from that guidance that the board will consider the previously non-instituted grounds on remand. And what about other circumstances? Well, this next case, tennis, has to do with an appeal of a PGR, post-grant review. The board had held claims unpatentable as indefinite. The court reversed on that and remanded to the board to address an obviousness issue. Along the way, says the court, we also want the board to have proceedings that are consistent with SAS. So, although SAS was a case about an IPR, the court extended that holding to cover PGRs as well. And then finally, here's a situation where neither party has sought SAS-based relief. So if it's true that the board lacks statutory authority to partially institute, what does that imply for the Federal Circuit's own appellate jurisdiction? Well, says the Federal Circuit, yeah, we still got jurisdiction. We conclude, says the court, that we do have jurisdiction to rule on the appeals. That is, the existence of the non-instituted claims and grounds does not deprive us of jurisdiction. There's finality here, says the court. The combination of the non-institution decision and the final written decision on the instituted claims and grounds terminated the IPR proceedings that are now on appeal. So they've got jurisdiction. Well, if you've got non-instituted claims and grounds, what's that mean about remand? Well, says the Federal Circuit, we need not and will not sua sponte revive the non-instituted claims and grounds. So there you have it. That wraps up what the Federal Circuit has actually been doing post-SAS. And let's turn now to Bill Robinson and what's going on at the district courts.
Yeah, thanks, George. Anybody who read SAS certainly had the sense that stays were going to become much more frequent in the district court, and what we've seen, we're a couple of months out of SAS, is exactly the case. We've got 4 cases that we can look at, which will tend to support that. Just as kind of a legal background, when a court stays a case, it's going to look at typically several factors: whether the discovery is complete, a trial date set, whether a stay is going to simplify the issues, and the issues of prejudice or tactical disadvantage to the non-movement. I think what we're seeing is the factor that's coming to the fore is really the simplification issue, and the Weiland case that we have on slide 12 out of San Diego. Judge Benitez focused on the issue of simplification, and the case was fairly well along. The Chia case, very much the same. The 2 most recent, we've got the Samsung Electronics case, which was very far along. You had not only a trial, but you had a jury verdict. Along comes SAS, and the judge says, well, we're just going to wait and see what happens. You've got the Huawei case, another relatively new case in which an IPR was instituted on a different patent, and the court just went ahead and stayed it. So, district judges don't much like patent cases to begin with, and this is just all the incentive that they need to be able to say, well, if anything simplifies anything, that simplifies my job, and therefore we're going to have a stay of the litigation. So we'll discuss in a little while the impact of Estoppel, but on whether you should even consider bringing an IPR. But certainly, once an IPR is brought, you can count on the district court putting the simplification factor at the very forefront and saying, well, if the patent office can do something, maybe I don't have to. And so that's really what we thought would happen. It's what is happening, and particularly with the kind of the all or nothing proposition of SAS. So since they've got to look at all challenge grounds, like I said, that's what the courts are going to be focusing on in deciding that it's better to stay it because the issues will be simplified. And with that, we're going to push it over to Andrew for some post-SAS PTAB guidance.
Right, thanks. Thanks, Bill. So immediately after the SAS decision, there was an initial set of guidance that the PTO issued. And on top of that, more recently, the PTAB has issued an additional, more extensive set of guidance in the form of some frequently asked questions and answers to those questions. A significant part of that guidance covers what you would expect it to cover, which is what is going to happen with an ongoing IPR or PTAB proceeding that involved a partial institution, and it's broken down by the stages. So what would happen if, for example, an IPR has been instituted, but the full patent owner response had not been filed, and there's guidance for parties to potentially request of the board certain relief. What would happen, for example, if it's a partially instituted proceeding and there has been an order, which I should have mentioned. So with respect to partially instituted proceedings post-SAS, what the board has done in the vast majority of those cases is they have issued an order modifying the scope of the originally partially instituted trial to include all grounds and all claims. And so, as you can imagine, that could create issues, and those issues will be different depending on the stage of the matter. So as I had mentioned, one example, the simplest example would be trial's been instituted, but the full patent owner response had not been filed. There could be another example of trial was instituted, the full patent owner response had been submitted, but petitioner's reply had not been submitted. And so with these particular stages, they bring in different issues. And so in the example of the circumstance where a reply has not been submitted, the parties may be afforded the opportunity to seek additional briefing. We've provided the link to the frequently asked questions guidance document here in the slides, and that will be an active link in the version that goes up on our website. And just as an example of some of the guidance here, the question comes up, will the board restart the statutory clock? And the answer to that is no, although they may, as they indicate, allow for additional briefing, evidence, and possibly even a supplemental hearing, and then would potentially extend the procedural dates under their good cause capabilities under the rules. So generally, with respect to PTAB practice, as I already mentioned, if there was no partial institution, there is no impact. Those cases continue on. If all the grounds and all the claims were instituted, there's no impact. With respect to cases where there was a partial institution, as I had already mentioned, in most cases, the PTAB panel has issued an order modifying the trial to include the non-instituted grounds and the non-instituted claims. And then, pursuant to the guidance that's also provided in the FAQ document, will offer the parties the opportunity to seek any particular relief that they want or would request based on the stage of the proceeding. So one specific example, which would be at the furthest end of the stages, would be, what if you have a case that was instituted and it's after the final written decision? And so there's two different circumstances. One, what would happen if the request for rehearing deadline had passed? And two, what would happen if that deadline has passed, but the deadline to appeal the Federal Circuit hasn't passed yet? And so in either of those circumstances, a party can ask to file a rehearing request either within the time period or out of the time period to seek the ability to provide additional briefing or evidence to address any of the newly instituted grounds that were not part of the trial in the first instance. On this slide, we have a specific example. This is Kingston Technology versus Polaris Innovation. So this is styled as an atypical example by the board. Here, SAS issued after a final written decision, and so as a result, certain claims that were not part of the original trial were now included because of SAS. And so here, the petitioner was authorized to file an at-a-time request for a rehearing for claims on which the trial was not instituted, and there was a total of 3 of those claims. With respect to one of the claims, the petitioner asked for a decision, and with respect to the other 2, they disclaimed their attack and asked that those claims be removed from the proceeding. The result of this was that none of the claims were removed from the proceeding. The PTAB found that the petitioner had not submitted sufficient evidence to show 2 of those claims were not unpatentable, the 2 that they had disclaimed their attacks on. And then interestingly, the other claim, Claim 4, was shown to be unpatentable over the prior art of record. And what the interesting aspect of this case, which is why it's so atypical, is the subject matter of Claim 4 was actually included in a substitute claim that had been addressed by the parties and found not to be patentable over the prior art. And for that reason, the board modified its final written decision to indicate that that claim, just like the substitute claim, was not unpatentable over the prior art, and indicated that the patent owner had been given a number of opportunities to address the patentability of that claim. So that's an atypical example. There are a variety of different ways that things are being handled by the parties, including additional briefing and things of that nature. And then one thing that will lead into the next topic is, what are parties doing? What are parties doing with respect to Estoppel? And in some instances, parties, the board allows parties, if they jointly agree, to remove certain grounds and certain claims from the proceeding that were newly added as a result of SAS. And with that, I'll turn it over to Bill for the Estoppel issues.
Yeah, thanks, Andrew. It's my sense Estoppel is going to be maybe if not the primary, at least a very significant impact of SAS. And if we look at the language of 315E, it's pretty clear as to why. I mean, in proceedings before the office or the district court, you're dealing with matters that you're going to be estopped on if it could have been raised during the IPR. Now, prior to SAS, the courts bent over backwards to prevent this from occurring, particularly the Federal Circuit Shaw decision, in which it said there was no estoppel if you could not do it, could not raise an issue during the inter-parties review. Cases such as credit acceptance, if the board hadn't reached it, there was no estoppel. If we go on to our next slide, Klondike, the estoppel was very limited. So, that's all the good old days. And where are we now? It seems that the rationale of Shaw and these other cases no longer exist. There's not going to be any non-instituted ground. You know, and there's certainly, I think as Andrew talked about, or George, the PTAB's not going to restart a trial if the scope is modified to include all grounds and claims. So maybe that's going to help you out in that limited situation. But it seems to me certainly that in terms of new IPRs that are filed, folks are going to have to be very, very careful in deciding even whether to file them, because once you've taken that shot, and hopefully is your best shot, you've kind of removed that ground from a district court proceeding. So to me, this drives up the cost of IPRs in terms of having to challenge everything, and it also drives up the risk because if you don't challenge something and could have, you're going to be stopped. So I think SAS is a bit of a game changer when it comes to Estoppel, and I think folks should look at very, very carefully whether they want to do an IPR. Now, we've got another slide here. You know, joint motions, the UMA versus Deep Green wireless case. You know, the parties together decided to exclude certain grounds. I mean, I think there's a certain tactical aspect of this, that if someone hasn't included grounds that they should, why would you ever agree to do that? So to me, if you're the patentee and someone challenges something and they didn't include something, I don't think you'd ever want to make it particularly easier on them to limit the impact of Estoppel in a subsequent PTAB proceeding or in the IPR. So again, it's for the IPRs. It's kind of a be careful what you ask for, because you could very well end up stopped in the district court. And obviously, it's going to take some district court jurisprudence to kind of work out the contours of the Estoppel. But reading the statute facially, it's a pretty significant impact. So that combined with what we discussed earlier, that the district courts are looking for any excuse to stay the case. So it's going to be stayed once it's the IPR is in. The district court case is going to be stayed once the IPR is instituted, and whatever happens there is going to stop you at the district court level. So while it makes life certainly interesting for those who want to consider IPRs, and I think there'll be a transitional period for the IPRs that are currently in progress, but I think for new IPRs, it's very clear that if you could have raised something and didn't, it's going to have an effect on later office proceedings or in the district court. That'll turn it over to Michelle.
Thanks, Bill. So as Andrew has already discussed, the PTAB put out guidance on how to handle trials that were already instituted, were in some point in the process. Now I'm going to address what is the impact on new institution decisions. We've had nearly 200 institution decisions since SAS came out. So we did an analysis of the various outcomes. Many of them weren't really different. It was a few claims, a few grounds. The analysis that the board put out was similar to prior to SAS. What we found looking at some of the other decisions, that the board will institute trial with an analysis of only one claim on one ground. So the first example, I need to go to my next slide, is here in Transova Genetics. So there, the petitioner had challenged 17 claims on 4 grounds. The board decided to analyze one ground for the only independent claim. The ground also covered 15 of the 17 challenged claims. The board found that with respect to that claim on that ground, the petitioner had presented a reasonable likelihood of success, so they would institute trial. Then based on SAS, they extended the institution to the other 3 grounds, as well as all of the challenged claims. So that is that's not surprising, but it is interesting that the board did not put out opinion on 3 of the grounds and many of the claims, so that will have an impact on the rest of the briefing in this trial. Second example of this, where they've only analyzed one of the challenged claims, is in our Seoul Semiconductor IPR. There, the petitioner challenged 9 claims. 8 of them were independent, and there were 4 separate grounds. The board analyzed one independent claim on one of the grounds, and they instituted on 2 of the grounds, and then they instituted on all 9 claims on all 4 grounds. Again, not providing an analysis on every single claim or every single ground. Then we have this interesting set of institution decisions where there were multiple claims, multiple grounds. This first one, Access Communication, had challenged 32 claims over 3 grounds, 1 anticipation and 2 obviousness challenges. The board had analyzed 1 claim in 2 of the grounds, one of the anticipation ground and the obviousness ground, and found a reasonable likelihood of success. However, for the 3rd ground, the board is very explicit that the petitioner failed to identify with particularity what limitations were obvious in view of the prior art. The petitioner failed to provide evidence that the allegedly obvious limitations would be obvious to a person with ordinary skill in the art. They did not provide a rationale to modify the prior art. The petitioner did not have any persuasive rationale that a person would have modified to include features of certain claims. And the petitioner failed to provide an analysis of why modification would produce predictable results. So on one of the 3 grounds, the board was very clear that it did not meet the reasonable likelihood of success. Yet, due to SAS, they institute on all 3 grounds and on all claims. So it'll be interesting to see how the patent owner might use the board's decision on the ground that it felt was inadequate. We saw in some of the modified institution decisions where the board had put out an unfavorable analysis of a ground that wasn't instituted, and then it had to be because of SAS. And we saw patent owners incorporating the arguments of the board, essentially saying, you've already put your position out, we're not going to need to pile on. So it'll be interesting to see going forward if in these cases where the board is specific about why a ground is insufficient, if that's what the patent owner will choose to do. The second one in this category, Saudi Arabian Oil, was a petitioner. They had 5 grounds, only challenging 1 claim. The board found 4 of those grounds where there's a sufficient likelihood of success. However, on the 5th ground, the board was not persuaded at all. And like the prior case, they said, well, you haven't done a sufficient job. We don't know why you would change out this element for that element and have any likelihood of success, but because of SAS, we will institute on that ground. So in the 3rd example in this category, Corient was the petitioner, challenged 3 claims and 3 separate grounds. It was 1 claim per ground. They found sufficient likelihood of success in grounds 1 and 2, so those were 2 of the claims. But the 3rd claim, they said it was did not establish any likelihood of success. But nevertheless, they will institute review on all grounds. So the 3rd ground and the 3rd claim that normally would not have been included. So in this case, even if the SAS had not been interpreted to include all grounds, because it includes all claims, this also would have been instituted on that 3rd ground. And my last example in this category for infiltrator water technologies, they had, I included this one because it was interesting, where they had 5 5 claims challenged on 4 grounds, and the board found likelihood of success for the first 2 grounds and analyzing one claim in those. The third ground, the patent owner had challenged under 325D, and that will be further talked about later in the presentation. But they challenged it as prior art that had already been considered by the patent office. And the board specifically said they would not deny granting review based on a 325D because of the institution of the other grounds. And finally, ground 4, there was no likelihood of, or no reason to make a proposed combination. But again, trial was instituted on all 4 grounds and on all challenged claims. And the last category was a very interesting situation in which there were 6 grounds, many claims, and the petitioner had included in its petition some indefiniteness issues for a means function claim, and the board found this, there was no likelihood of success, and the indefinite issue couldn't be challenged at the PTAB, but there were 3 claims that were method claims that were interspersed amongst the six grounds, and the board would not institute this trial, even though the method claim would not be subject to the means plus function arguments. But if they were to institute trial on the method claims, under SAS they would be compelled to institute on all the claims, which the board had discussed at length. It would be the challenge claims are not amenable to construction. The petitioner is not permitted to pursue a ground of indefiniteness, and indefiniteness would be a significant issue for all the apparatus claims. So they denied instituting trial on the method claims because those claims would be dominated by would be really infected by the indefiniteness of the related apparatus claims. So that was a situation where perhaps post-SAS there would be a different choice by the petitioner how they would frame their petitions. Perhaps it would lead to 2 separate petitions to keep the apparatus and the method claims separate. And finally, just a little statistics, because that's what we like to do. This is from the Patent Office. So prior to SAS, about 62% of the petitions were instituted, and the rest are denied. Now we're at 60%, so it's not a significant change. Going forward, it'll be interesting to see in the fall when the new petitions, the petitions that were drafted with this post-SAS knowledge, when those start to be evaluated by the board, will institution decisions shift the percentage. So that's everything on current institution decisions, and now I turn it back to Bill.
Oh.
Actually, to Taylor, sorry.
At this time, I'm going to read the CLE code program. If you are in need of CLE credit today, please enter this 5-digit code into the full question on the screen after it is announced and press the submit button. Code is R4RUU. Again, that is R is in rock, 4 is in the number 4, R as in rock, U as in umbrella, and Q as in again, last time, R4RUQ. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. At this time, the poll is now closed. I would like to return the program to our speaker.
Hi, this is Andrew. Bill, we have a question that we might address here from one of our participants. It says, going forward, do you think that attorneys will attempt to assert more and more frivolous claims to force an increase of costs and forced settlement?
You know, it's an excellent question, and it kind of segues into what the PTAB is doing under the AIA with its sanctions requests, 37 CFR 4211. The short answer is they're not doing much. 4211 contains the duty of candor and good faith requirements, and basically includes some Rule 11 type sanctions for non-compliance. What's happened, though, is that they've set kind of a high bar for sanctions motions. I think there was a case involving Apple a while back in which they had requested sanctions because of certain positions. The other side had requested certain sanctions because of Apple taking inconsistent positions. The PTAB didn't do it. I think if you've got a frivolous claim, you know, this is an area of the law, much like Estoppel, which has got to be developed. And since there are such tremendous effects for Estoppel and, you know, the stays in the district court, I think it's going to be worth pushing parties under Rule 42.11 or 37 CFR 4211, and to develop that body of case law, because as the question certainly points out, there's tremendous possibility for abuse by trying to assert frivolous claims and drive up everybody's cost and force a settlement. As we all know, patent litigation, which has been called the sport of kings because only kings can afford it seems like, it's one of the most expensive kinds of litigation that you can do. And certainly, if people are abusing it, then people should push back. And I think it's going to be up to you know, all of us to do that and to develop a law that kind of keeps people honest in the IPR process. Hope that answers the question.
Yep, thanks, Bill. So the last topic of our presentation today is the effect of Section 325D post-SAS. So here on this slide, we have the language, the pertinent language of 325D, which provides to the director the discretion to reject a petition because the same or substantially the same prior art or arguments were previously submitted to the office. And so where this is potentially interesting is with respect to the all-or-nothing approach that we are now faced with in SAS. And so consistent with that, and again, I would encourage folks to look at the frequently asked questions and answers document that I referred to earlier, which is understood to be something that's going to be continually updated by the PTAB. The question then becomes, you know, what could potentially happen if something is submitted in terms of a petition that may implicate 325D, and how would that be affected by the all-or-nothing approach? And so with respect to ongoing cases where there was a partial institution, the board has indicated that they don't anticipate vacating any of those under those circumstances. And then on the front end, as we go forward, parties should be cognizant of 325D and its potential effects with respect to the all-or-nothing approach that we're now seeing at the PTAB post-SAS. I'm looking. So we don't have any other additional questions at this time. We would, of course, encourage those.
Andrew, this is George Quillen. A question has come up about the Polaris case back on slide 7. So let me see if I can.
Do you want me to do it? I can navigate it.
If you can bring up slide 7. Yeah. So on Polaris, let me be more clear. This has to do with whether the patent owner could request remand. The petitioner had said, no, you're the patent owner. You can't request a broader institution. But the court said that no, Polaris can indeed request a remand to allow the board to consider the non-instituted claims and grounds. A patent owner, says the court, a patent owner has an interest in obtaining a final written decision that addresses all the challenge claims and resolves all the questions of patentability that might otherwise cloud the perceived validity of its patent. And again, all this happened after a briefing had been done, and so the petitioner says, well, even if they could otherwise raise it, they can't raise it now. They waived. They were the appellant. They didn't include it in their opening brief. They're waived. The court said, no, that's not right. Says the court, precedent holds that a party does not waive an argument that arises from a significant change in the law during the pendency of an appeal, and SAS was such a significant change in the law. So it's okay, says the court, the patent owner can raise it here. So that's Polaris. There's also a question that I'll direct to Michelle on the institution decision. So SAS, as we all know, says that the board has this binary choice, up or down, institute or not institute. So Michelle, there's been some speculation that what the board might do is merely simply that, up or down. So the board's institution decision is going to say instituted, and that's it. Have you seen anything like that in your survey of these very many recent institution decisions that you've looked at?
No, George, I have not seen the simple, up or down, one word response. They are still continuing to at least analyze one of the challenge claims within one of the grounds. So they're still giving some guidance to the petitioner and patent owner as to their thoughts on the petition's effect.
Okay, well, thank you very much. We invite questions from the audience. As it turns out, we do have ample time for a Q&A. We'd be happy to respond to questions that y'all can send in. Taylor, while we're waiting.
George, this is Bill. I have a question for you. Do you think that, given the increased burden that SAS is going to place on the PTAB, how they're going to handle that administratively in terms of just with the people power needed to, whether it's a one-word up or down institution decision? It seems to me that there's a lot of administrative fallout that's going to occur from SAS. What do you think about that?
Yeah, I think that's right. The board, to the view of many, has been remarkable in its ability to handle this influx of work. So there's not only the current IPR load that they have to handle, but now they've got scores, maybe hundreds of other IPRs that they thought had dealt with, and now they have to revisit and issue a revised institution decision. They've got more cases coming back to them on remand, cases that have been already gone to a final written decision, and a party says, "Oh, we want you to reinstitute on the non-instituted claims and grounds." So the board so far has been doing all that. And in
do you think there's going to be less IPRs? I mean, my sense is, since with the all or nothing approach, you're going to have to take your invalidity shot on the kind of prior art the PTAB can consider at the IPR stage, because you're not going to be able to do it at the district court stage with the Estoppel. Do you think there'll be more IPRs or less IPRs as a result of SAS?
Yeah, I would say less, I guess, if I had to choose. There was some concern early on when the IPR statute has language in it like the inter partes re-exam statute about issues that you raised or could have raised. And there was a real concern about the scope of the Estoppel. With the partial institution, the board took some of that away, some of that concern away, and as we all know, they've become famously popular. Now that it's back on, there's a real risk to a petitioner about issues that one raised or could have raised. So one consequence could be fewer IPRs, although sort of perversely, another possibility is that there could be more petitions, assuming a petitioner can afford it. That is to say, if a petitioner has to have all its assertions, all its challenges raised, or face Estoppel, and you can't sort of junk up a single petition, maybe there'll be more petitions. So several petitions against a single patent instead of just one. Several petitions against particular claims instead of just one petition. Consequently, if the board says, no, we've already instituted on claims 1 to 10, we're not going to have another IPR on these same claims 1 to 10, then maybe the petitioner will be spared Estoppel. But
yeah. And apropos of that, there's a general question that came in. How long does the panel think that this chaos at the PTAB will continue in a follow-on? What is the chance that Congress will intervene with meaningful curbs on this process? I'm not sure our Congress can do anything meaningful, but that's at the moment. But I hope if they do, they start with 101. That's a whole different issue than this. I think a lot of the problems that we face in the patent system, Congress has got to come around and fix. As far as the chaos, I think, like with any other change in the law, it's a process that's going to shake out over time to see what happens in terms of the mechanics of how the PTAB handles IPRs internally, from the staffing, from whether their decisions are simply up or down. So I think we've got to give it some time. So I'm not sure it's chaos, but it is the government.
That's true, and they seem to the board seem to take seriously this statutory limit, and have been very hard at work churning out decisions. So we'll, as you say, we'll see. I guess time will tell, as we say. But it'll be interesting to see how.
As someone said, yeah, we live in interesting times, particularly the patent office.